This lecture is on the legal aspects of sonography. Professional sonographers must be aware of the legal and ethical issues associated with a patient care environment. Although sonographers often work under the direction of a physician, they are still responsible for any harm that a patient may suffer as a result of their actions. This is why society demands that healthcare professionals conduct their practices according to accepted standards. Failure to do so will lead to a civil action. Civil laws are laws that affect individuals rather than society as a whole. Sonographers follow the regulations that are documented by the Society of Diagnostic Medical Sonographers. Accountability. You are accountable for yourself. Legal rights of patients are strongly emphasized in healthcare professions. Professional accountability plays a role in legal consequences. Accountability is responsible for events that you may have to give judicial explanation. As I said earlier, the Society of Diagnostic Medical Sonographers is the regulations that sonographers follow. Sonographers need to understand the basic restrictions and laws placed upon healthcare providers to prevent lawsuits. There are three different types of laws. One is statutory laws, which is enacted and enforced by federal or state legislators. These uphold social order and protect the rights of individuals. Second, administrative laws is made by administrative agencies appointed by the president or governor. One type is the Occupational Safety and Health Administration, OSHA. It's a federal agency that regulates many companies. Common law is a court-made law based on custom and usage. Most malpractice laws are court-made laws. When sonographers fail to meet their professional responsibilities, patients may file suit. Most cases brought against sonographers are called tort actions. A tort is a wrongful act other than a breach of contract for which the law provides a remedy. Torts can be divided into two categories: intentional and unintentional. There are many different reasons why someone would file an unintentional tort. But for the sonographer, the main two are for breach of confidentiality and invasion of privacy. With the advances of computerized health records, this allows the intrusion into someone's private life obtainable by many people. HIPAA legislation, which was established in 2003 and became effective in 2005, is a big thing in all hospitals and most healthcare clinics. Any type of information about a patient that could be released without their okay is an example of an intentional tort. Another intentional tort that could be filed suit against a sonographer is for false imprisonment. This can be performed when a patient is restrained by mechanical or by verbal means. When you are taking care of a patient without a doctor's order, that patient cannot be tied to a litter or strapped down. And we also need to be very careful of what we say to the patient who is refusing to have an exam. You cannot make them feel threatened that they are then doing the exam because they are fearful. They have to be able to feel free to say no to getting an exam performed on them. An unintentional tort is negligence. It's failure to use reasonable care. This is a cause for a medical malpractice, and for the sonographer, the most likely scenario is a misdiagnosis. Medical malpractice occurs when negligent act or omission by a medical professional results in harm to the patient. The injured patient must prove 4 elements: duty, breach, harm, and causation. Duty refers to the standard of care that the medical professional is required to follow. Breach refers to the defendant's failure to meet that standard of care. Harm refers to the injury suffered by the plaintiff. Causation requires that the defendant's failure to meet the standard of care was the actual cause of the plaintiff's injury. Informed consent is a unique area of medical malpractice law. A patient has the right to prevent unauthorized contact to his or her person. The healthcare professional must disclose information that lets the patient make a knowledgeable decision about proposed procedures or treatments. This can be either written or spoken. In most facilities, it's required that the patient actually signs a consent form, and in the consent form it is listed all the pros and cons of having the procedure done. It's giving the doctor permission to do the procedure, and if any pathology or samples of the pathology are removed, it's also giving the doctor permission to give that pathology to the lab for evaluation. If you look on page 164, there's box 7-1, and it does document the legal requirements for informed consent. Just going over them quickly, you need to describe the procedure, clearly state the risk and benefits, discuss possible outcomes, discuss alternative treatments, and make sure the consent form is signed. In addition to being signed, it's also good to have it witnessed and dated. I just wanted to touch lightly upon implied consent. Most sonographers really would not have to deal with that type of a situation, but it's a consent that it's understood from the circumstances surrounding the procedure. If a patient has a life-threatening situation and is unconscious or unable to communicate, a surgeon may perform necessary procedures during the course of a surgery to which the patient granted express consent. Or a patient may come in to the hospital unconscious or unable to sign, and due to his or her life-threatening injuries, the surgeon is able to go ahead and perform a procedure on that patient. Liability for the sonographer, it does fall upon a few different levels. The sonographer is legally responsible for their actions. The sonographer's employer is then also responsible for their actions. Also, the radiologist is responsible for that sonographer's actions. Employers can also be liable for sonographers who are not employed through that facility but are a contractor or some sort of an independent agent. So a sonographer does have liability for themselves, the radiologist has liability also for what the sonographer performs, and the hospital overall is responsible for the radiologist and the sonographer. Since a sonographer is liable for their actions, sonographers do have a right for protection. Although sonographers generally work under the direction of a physician, they are still personally liable for any harm a patient suffers as a result of their acts. There are two types of malpractice insurances that a sonographer can purchase. There's a claims made policy, which states that you are responsible for the claim that's being brought up against you. And there's an occurrence policy. The occurrence policy covers you under a claim that may have happened in the past. So when you purchase the insurance, it will cover you for that time. So if you have a claim brought to you, say 4 years after you have purchased the policy, you are still covered within that time. On page 167 in box 7-2, this just gives guidelines for defensive scanning, something to protect yourself against. Insist on written request. Always make sure that the provider is giving you an exact request of what they're looking for prior to doing your ultrasound. Do not perform any scans or procedures for which you have not been trained. Don't let someone throw you into doing something that you're not prepared for. Determine if a chaperone should be present. Ensure that the patient understands the procedure and why it is being performed. Make sure the equipment is adequate for the requested study. Be aware of all common pitfalls resulting from incomplete patient preps and artifacts. So if a patient was not properly prepped and a radiologist or a provider is requesting you still to go ahead and do the study, make sure that you document that the patient, say, was not fasting for 8 hours, or say that the patient had a large amount of bandages on the abdomen that prevented you from getting a good view. Use the department protocol for varying an ultrasound exam. Always record images containing diagnostic content, and document your findings, noting any technical difficulties encountered. If you have to do a patient portably and the patient has limited mobility, make sure you document that on your paper so that the radiologist knows and it's documented that you really couldn't get beautiful pictures because of all those limitations. From a legal standpoint, a sonographer's best friend is documentation. From a risk management perspective, the medical record is the most important element to prevent and minimize the consequences of liability in a malpractice suit. There are a few steps that could be taken if a sonographer is subpoenaed. Subpoenaed is a court document that requires a witness to appear and testify or to produce documents or papers pertinent to pending controversy. Ways to protect yourself as a witness is, if you have a professional liability insurance, contact your insurance company and an attorney will be assigned to you. And if you are covered by an employer's policy, consult with the legal risk management department immediately to obtain consult. A lot of times, if you are subpoenaed, you will have an attorney with you, either from your professional liability insurance or from your employer. At some point, you may become an expert witness. Whenever a sonographer is a defendant, the ideal expert witness is another sonographer with a similar level of education and experience. In this type of situation, you will be asked if you agree with how that sonographer had handled the situation or made a diagnosis. An expert witness must be able to analyze the facts presented and draw their own conclusions from those facts. In summary, make sure that you always use your best judgment when interacting and providing care to a patient. Always think ahead to ensure the game plan you use is individualized for each patient and scenario to prevent avoidable situations. Hopefully, avoiding those situations would prevent you from having a lawsuit brought against you. In the next class, you will be responsible for knowing the key terms on page 160.